Michael Popok, Legal AF. Take out a calendar and a red magic marker and circle September 5th on your calendar at 10 a.m. because that's when Judge Chutkan is going to be holding her hearing about how to put the D.C. election interference case, 4 felony counts against Donald Trump, how she's going to put the wheels back on the wagon and bring that case in. We thought a lot of this was going to happen in August, but frankly, as I reported in an earlier hot take, Jack Smith, the special counsel's office, he needs a minute. He needs a minute to figure out how the immunity decision on July the 1st, issued by the United States Supreme Court, how it rocked his world. He's got 2 decisions he's got to decide on, and he needs time. He's got U.S. versus Fisher, in which the Supreme Court did a solid for the Jan 6th insurrectionists and let them all off the hook related to interference with an official or obstruction of an official proceeding, which was the congressional count of the Jan 6 electoral votes. But that doesn't mean Donald Trump's off the hook because he used fake elector certificates as alleged in the indictment, which would seem to put him squarely within the court ruling. But there's a lot to be done, and Jack Smith asked for a 3-week extension. He put up his hand. He said to the Professor Judge Chutkan, I need 3 more weeks to answer your question about how the immunity decision applies to this, because he wants to be ready to brief it, put it in briefing, and then he wants to be ready to have that kind of evidentiary or mini trial hearing that the Supreme Court suggests that Judge Chutkan have to conduct. And now we've got a new order. She has granted Jack Smith's request that was unopposed by Donald Trump. Donald Trump, that was music to Donald Trump's ears. A delay? Do I hear a delay is necessary? Yes, I'll take at least one of those. And so he didn't oppose it. If he opposed it, the judge would have given it to the special counsel anyway. So we were supposed to all be in court on August the 16th. That's when the judge originally wanted it. But now she's going to make it September the 5th. Which Donald Trump's side has said that they're available. They had one date that week. They weren't available. This is right after Labor Day. And she said, all right, then everybody come in at 10 a.m. Trump, you don't have to come in. But the lawyers come in and talk to me then, and the government better be prepared at that time to provide me with their position as to how to get the immunity decision. You know, if you're going to use it as like a meat grinder, how do I take your indictment and run it through the meat grinder or the filter and have an indictment that's valid come out the other side? Tell me all about that. And as I said, it's a harder decision for the Department of Justice because they've got like a 10-level chessboard with multiple consequences, intended or unintended, but they can't be accused of not being thoughtful. And they're going to have to put all of the division heads, civil and criminally, around a table. I'm sure they've been doing that in frequent meetings. There's memos being written by young staffers, staff attorneys, prosecutors, line prosecutors, senior people all over the place, to their boss, to their boss, to their boss. Ultimate audience is Merrick Garland. That's the Attorney General, Department of Justice, his deputy, Lisa Monaco, and others, and the special counsel and his office, right, as an employee and an inferior officer under the Department of Justice and the Attorney General. So it's going to take a minute. And he's not ready. I mean, he's had like a month, but he needs more time because there's a lot of decision-making here. They got to think about what happens to the Jan 6th insurrectionists now, in the past, in the future, the next insurrection, and the like, and how this kind of precedent, how it could ricochet, and what is the likely path. They got to come up with all of that, and they're not ready yet. And the judge said, fine, I understand. This is a big decision, right? It's not that our heads hurt, but it's a big decision, and it's an important one. Measure twice, cut once. So she gave the government what they asked for, but she wants everybody in on September 5th. Now, she's on vacation because she let it be known she's on vacation. I don't exactly know where in August. I think she's on vacation kind of right now while she's issuing these orders. But she wants to see everybody in less than 30 days. And from there, they'll decide the briefing that will be required, the timing of that briefing, and any kind of companion evidentiary hearing she may require, a mini trial, in order to get to the bottom of the immunity decisions application, to the indicted charges and allegations and operative facts, if you will, overt acts of the indictment, and then the counts in the indictment. She's got to decide all of that. I know as well as the next guy that sex life is important, but your schedule is busy. You don't have time to go to a doctor's office to get treated for ED. Through HIMSS, you can get a personalized ED treatment without stepping foot outside your door. HIMSS is changing men's healthcare by providing access to affordable sexual health treatments, all from the comfort of your couch. HIMSS provides access to a range of doctor-trusted ED treatments such as chewable hard mints, proven treatments like Viagra and Cialis, or their generics, for up to 95% cheaper. The process is simple and 100% online. No uncomfortable doctor's visits. Just answer a series of questions on their site, and a medical provider will determine the right treatment option. If prescribed, your medication ships directly to you for free. No insurance is needed. Pay one low price for your treatments, online visits, ongoing shipments, and provider messaging. HIMSS has hundreds of thousands of trusted subscribers. So if ED is getting you down, it's time you find the option that works for you. Start your free online visit today at hims.com/legalaf. That's HIMS.com/legalaf for your personalized ED treatment options. hims.com/legalaf. The products mentioned are chewable compounded products, which are not approved by or verified for safety or effectiveness by the FDA. Prescription require an online consultation with a healthcare provider who will determine if appropriate. Restrictions apply. See website for details and important safety information. Subscription required. Price varies based on product and subscription plan. So my gut is, just to give you a little bit of how this works, from being a federal litigator, trial lawyer in these kind of courtrooms, what's going to happen is they're going to meet on September the 5th. After hearing from both sides, the government's going to say something like, we could have a fully brief within the next 2 weeks. And Trump's going to say, no, I'm a candidate for office. It has to be sometime in 2025. And the judge is going to go, all right, let's give everybody 3 weeks, or 2 weeks for the government. I think that's reasonable. 2 weeks for the other side. Let's get all briefing in and done by the first week in October. It'll be something like that. And then she's going to hear, what do you think about procedure? I make the ultimate decision. I'm the judge. I'm wearing the black robe. I've been given the lifetime appointment, or at least until I'm 70, when I have to go senior status. What say you, government? Government's going to say briefing. And if the court is so inclined, we're willing to put on our evidence consistent with the Supreme Court mandate. And we will be prepared to put on witnesses. That's interesting. Mr. Trump, no witnesses. No witnesses, just briefs. You don't need witnesses. This is an indictment. Why do you need a mini trial? And the judge is going to have to decide what she needs procedurally. More importantly, she's going to have to decide what the Supreme Court wants her to do. They already sort of wrapped her knuckles in their order. They said, well, what you should have done at the beginning is you should have gone through the indictment with the executive privilege in mind, or presidential immunity in mind, and you should have been more mindful of that. And you should have applied it and done a factual analysis, an intensive factual review then. Well, judges say, okay, fine, I got to do a factual intensive review now, and maybe I need to be assisted by additional evidence being brought in by the prosecutor. The reason I'm not sure that happens is because the indictment has to rise or fall on its own. The indictment came out of a grand jury process in which, for right now, secret evidence was presented. You get the evidence at the end, but you don't get it now. And that evidence was presented in witness format, in document format, and then the indictment has to rise or fall. You can't supplement the indictment. Indictment can't be supplemented with, well, we made a great argument during the grand jury presentation, and so here's the slideshow from that, or here's the record, or here's the document from that. The indictment has to arise and fall on its own. Now they have discovery and document disclosure obligations the government does for a criminal defendant, regardless of their name or their former status. I get that. But they don't get to supplement. If the indictment is strong and survives a motion to dismiss, then it survives a motion to dismiss or the application of immunity, or it doesn't. And it can't be supplemented in some other process. I'm not sure about the evidentiary hearing. I've kind of been of two minds on that. I think it's just going to be a briefing schedule. And now we know the target of it. So here's what the judge said. Let me just read you from the judge's order so that we're all on the same page. Minute order, sort of her version of a paperless order we've talked about with Judge Chutkan. Minute order as to Donald J. Trump. The government's unopposed motion for extension of time, which was docketed on the docket, I think as 210, is hereby granted. No surprise, Trump didn't oppose it. The joint status report, previously due by August 9, which is today, is now due by August 30, giving Jack Smith exactly what he asked for. The status conference, previously scheduled for August 16th, is now continued until September 5th at 10 a.m. in courtroom 9. That's it. Now, in her prior order about the status conference on the 16th, she made it be known that Trump could, but didn't have to be there for this particular argument. Sometimes judges in criminal court require, arraignment, you got to be there. Reading of your indictment, you need to be there. Sentencing, like Judge Merchan in September, you got to be there. But other things, kind of more run-of-the-mill, procedural issues, substantive issues, you can go if you want. And she's told him that, even though it doesn't say it here. I know from the prior order on related to the August 16th original date for the status conference, she was okay with Trump not being there. Now, Trump likes to use his appearances as campaign stops. And since he's really not doing any other campaigning to speak of, I have another hot take up on that. He's virtually abandoned his campaigning. Maybe quiet quitting. That's been a speculation. He's sort of phoning it in. He's substituting photo bombing Kamala Harris's airplane and using banners that backfire on him because it looks like they're promoting Kamala instead of disparaging her. And they've scheduled one rally for this current important week. There's not that many weeks left on the calendar until November 5th. And it's in that hotbed battleground state of Montana. While Kamala Harris, the big Mo, the Surge, Vice President Harris, and Governor Tim Walz are going on a whistle-stop tour to all the battleground states. So you got that going on. So Donald Trump, though, doesn't like to be yanked off the campaign trail, but frankly, he's because of lawsuits, but he's yanked himself off the campaign trail. But he may try to arrive. I think my colleague Ben Meiselas put it best a couple of weeks ago on Legal AF. He said Trump's running out of venues to promote his and spew his illogic and his dystopic and apocalyptic view of the world and his ramblings and his rantings. Now he's got a Mar-a-Lago and, media cameras are clicking off and viewers are clicking off within 10 minutes of a 1 hour rambling attack, unstable attack. So he may show up at this hearing. He can't do anything in the courtroom. I mean, he could, but there are federal marshals that could take him away. But, he's been known, he loves setting up behind these bicycle racks or doing these impromptu press conferences in the hallway of a federal court or outside the federal court because, there's a tension. He operates from the school. I love when I inadvertently set off fireworks. Speaking about fireworks, he operates from he's an OG. Literally. He operates from the school of any news is good news. Terrible news is good news. Notorious news is good news. As long as they're talking about me, it's good. It saves me money on my advertising campaign. And since he's always whining about he lost $100 million in campaigning against Joe Biden. He wants it all back. He wants the Democrats to refund his money. While he's busy defending Joe Biden, he's already wistfully missing Joe Biden. Have you seen those clips? Oh, it's so unfair what they did to Joe Biden. I mean, he just had one bad debate performance and they just threw him out. That's terrible. They're terrible people, those Democrats. Okay, crocodile tears. We're on to you. But Chutkan, I'm a betting person. I think he shows up. I think he does a press conference. I think we'll cover it on the MeidasTouch Network and on Legal AF. You're already here. If you haven't free subscribe, why not? It's free. You like our content. You're already here with me, 12 minutes into a hot take. Free subscribe. I think we're going to get to 3 million, what a number, of on this independent, no outside investor network, pro-democracy, by Labor Day. I don't think it's election day anymore. Make an honest man out of me. Help get us to 3 million free subscribers. It helps. And every little bit helps. We can't do this without you, literally. Not corporate media. We're people powered. We're Legal AFer and Mighty powered. And so if you like what we're doing, tune in on Legal AF on Wednesdays and Saturdays at 8 p.m. Eastern Time on this YouTube for a live recording of our full-length podcast at the intersection of law and politics. And then just plug in Legal AF on all the places you get podcasts from, wherever you get them from, and we'll pop up and you can free subscribe to that as well. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.